morning, and good afternoon to in-house counsel from all across America. Welcome to In-House Connect. My name is Shai Mahani. I am the CEO and co-founder of In-House Connect, and I am thrilled to have you with us here today. Thank you for spending your lunch or your breakfast time with us. And special thanks to our presenter and sponsor today, Dave Stevens of the Stevens Law Group. Let me give you a quick bit of background. In-House Connect started about 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE classes hosted by different law firms, which were followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel, truly from coast to coast. We've been able to facilitate way more networking and relationship building, and we've been able to feature high-caliber speakers like the one we have today, who I'm going to introduce in just a few moments. Today's event, Trade Secrets for In-House Counsel. Our presenter today is Dave Stevens. Dave Stevens's IP practice includes patent prosecution, transactions, due diligence work, agreements, opinions, including validity, infringement, patentability, right to practice, and freedom to operate opinions. He does counseling, offensive and defensive, patent issues, licensing, and litigation. He also serves as an expert witness in technical and intellectual property legal issues and has been called as a fact witness in enforcement actions, including the many patents he has written. He is also an expert in copyright, including software, publications, products, and artworks, and other copyrightable forms, and open source issues. He works with foreign IP firms and foreign clients with respect to domestic and international patent prosecution, including patent cooperation treaty work. The technical focus of his practice includes electronics, computer technology, automotive technology, communications, optical systems, green technologies, software, semiconductors, and mechanical devices. We are so glad to have Dave with us today to help us understand trade secrets. And with that, I'll turn things over to Dave.
Thanks, Shai, and thanks In-House Connect. Really great to be here. Nice to see a nice full house. So yeah, today we're going to talk about trade secret fundamentals. I've got a slideshow that, of course, we'll share afterward for a pretty good reference. And if you have any questions, please feed them into the chat room. I'll try to cover them as much as we can. I got some early questions before we started, so I included those in the slides, and I'll make sure that I address those. So again, we've got a pretty full house. Hopefully we'll try to hit all these questions. If not during the talk, then during maybe the chat rooms. So yeah, so our collective purpose as legal professionals really is IP asset education, capture, and management. Now, I like this visual here. This is, in fact, it's from Chesborough. I might as well give him full credit for this. He does open innovation. It's actually a really good read. What I like about this visual is that it shows where intellectual property, especially trade secrets, come and go in a company. Now, if you look at the closed innovation model on the left, it's typically what you see in, say, like a Department of Defense or military kind of structure where everything is kept inside, nothing is shared outside, and security is super high. But that's not really what the norm is these days, especially with civil companies. Open innovation is really the key. And as you see from these little dots, this is where ideas come and go, concepts come and go. And as I mentioned in my paper, everything starts as a trade secret. So nothing is really born a patent, copyright, or trademark immediately. It really starts as a trade secret because they're created by people. And once a person creates this within the confines of their employment, their job, project, whatever they're working on, it's a secret. And in order to really to protect your ideas, especially the concepts that a company wants to keep exclusive, you want to be able to capture them as they are created. And being mindful of all the different aspects of your business and where ideas come from, whether they come from the outside in, inside out, or kept internal. And the focus today is to hopefully give some structure and some advice and some teachings on how you can be more deliberate in your processes, your structure, your policies, so that there's no surprises when things like trade secrets, patents, copyrights, and things are discussed. You know where they are, you know how they're protected, and you have visibility on these things. So the goal really for any in-house counsel, outside or inside, is to become an expert IP strategist. And what does that mean? So you want to be a sophisticated consumer of IP services because you can't do everything in-house. The days of extensive in-house groups and staff there's only so much you can do, especially as a company grows. And when a company is really small, it doesn't make sense to have all of these different experts if there's frankly not enough work to do, right? And you don't need to be a registered patent attorney, a trademark expert in order to be a strategic expert for your company. There's enough that you can know and that you should know that makes you a smart consumer of IP services. So you really want to do that by understanding the product that you're managing for the company, that you're purchasing on behalf of the company. Lawyers, vendors, different companies that support your trade secret, patent, copyright, trademark processes. You need to understand them as well as any of the experts, and you can. In fact, by the end of this talk, hopefully you'll understand enough about trade secrets. You can actually put these concepts to work immediately for your company, because some of them are pretty simple. They just need attention, right? So ultimately, your superpower is turning the valuable ideas into strategic assets. Trade secrets are strategic assets. You just need to keep them secret. We'll talk about how to do that. Patents, copyrights, so you can't turn everything into a patent. You can't turn everything into a copyright, right? These are all different tools in your toolbox so that when you lay out your holistic program, holistic system for protecting your IP, you'll have these different tools and you'll categorize certain parts of your technology and general business data and information in different buckets so that these different tools will be used to protect and address what you need. And your ultimate destination is a seat at the strategy table, because you're not just a service provider when you're managing IP. If you understand the company's technology and IP enough, then you're likely to get invited to a seat at the strategy table with the CEO, the COO, and all of the different business development folks, because what you do, what you manage, what your system creates can be used as strategic assets. And if you understand them and understand how to protect them, then you can counsel the CEO and everybody else, all the stakeholders, on how to use these things in negotiations and sales, in customer engagement and different things. So the more you know, the more you can help these people be strategic. So trade secrets are intellectual property, right? What is a trade secret? So a trade secret is any kind of data or information, so first of all, that's not generally known to the public. And it includes any kind of secret shared under an NDA or the like. That is, any contract, joint development, anything that your company engages in where you have confidentiality terms, those are for trade secrets. Those protect your trade secrets. Once things get patented, they get published. They're no longer trade secrets anymore. Trade secrets is the initial umbrella that protects everything that you have. Now, a trade secret, in order for it to be a trade secret, needs, of course, to be kept secret. And it needs to have commercial value because it is a secret. Customer list. I'll go through the list of all the different things, but for the most part, it's any kind of information that gives any kind of strategic edge or advantage to the company because you hold the secret and nobody else holds the secret. Data algorithms, all types of inventions, cannabis strains. Now, that's one of the questions that came in. I threw in cannabis strains, and I thought that was an interesting angle. In the old days, I think the biggest trade secret about cannabis strains is where you're hiding your crops. But now that it's legal, cannabis strains are no different than any other, biology type patents. Different types. Monsanto wrote the book on different types of, growing products and different things. And cannabis strains are the new thing. These things are trade secrets as long as you keep the secrets, right? So if for cannabis, for example, when you sell the cannabis, unless it can be reverse engineered to understand what the strain is, that thing is a secret, right? So it's viable to be a secret. And you can also file patents on these different things, but they begin as a secret when they're first created. It's important also to note that non-published patent applications are still trade secrets, right? I mean, everything's a trade secret until it's published or disclosed. And patents are published 18 months after you file a patent application. And in fact, you can extend that by requesting non-publication. So if your patents and all the information inside of them are not published, those are trade secrets. So you need to treat them as trade secrets and protect them just like you do trade secrets. Government contract submissions. I mean, that's another completely other different field. But aside from, national security and different things like that, there are things that are developed just like you do a joint development with another civil company, where you have lots of technical information, tactical information, and business information. All of that is subject to trade secret protection. Interpretations of public data, failed experiment data. And most people don't think about that. I mean, often what happens when you're developing a technology or developing a product, there's a bit of trial and error there. Different methods and things don't work. You find just better ways of doing it. And that failed experiment data is equally as valuable. For example, I have a client that does 3D printing. And what's unique about what they do, it's area 3D printing instead of that point 3D printing. Extremely unique. They are the only company that's able to accomplish it right now. There are competitors, and there must be a dozen of them, but they are aware of every single thing those competitors are doing. Why? Because they're aware of what was tried and what was failed. They understand it very well. And that trade secret information, I mean, it eventually comes out when they start talking about their products and things. But this client looks at all these different things and he takes great comfort because he knows that many of these competitors are out there destined to fail because the secrets that he holds are more experience. He was in there earlier and he did much more research and he understands the things that fail. And in many positions, especially now, since there's no product out there yet, he closely monitors what's available out there. And, he understands where his company is and how far ahead they are because he sees other people trying things that he's already seen fail, right? Interpretations of public data. Now, this is an interesting thing. Now, you think public data, well, that's public. That's not a secret. That can't be a trade secret. Well, if you organize and pull together this information, there are ways of interpreting large amounts of data that might not be evident or clear to the public. And it's a trade secret. It's a trade secret when you don't pull things together. For example, client and customer list. That was one of the questions that came in too. Give us an example of client or customer list. Well, you could have a product, your competitor could have, another product, and they may not even know the client or the customers, whether they even exist, whether they even want this product. And that information alone is enough to leverage and go after your customers. And the different contact information, you think it's easy to get a hold of people nowadays, but finding the decision makers, I mean, that stuff is really valuable. And business development people, marketing people, sales people, I mean, they have extensive systems and it's an awful lot of work to get this information, gather this information and establish clients and customers. In fact, they may have created customers that didn't even exist before. And they wouldn't have existed if they didn't curate them. And so I'll give you a kind of an embarrassing story about this. I'll share with you that actually happened to me. See, it doesn't just happen to companies. It also can happen to lawyers who specialize in trade secrets. I had a venture capitalist who sent me a lot of work. In fact, I worked for their whole portfolio, very big portfolio, many companies. And I would always get all their patent work and do all the different things for them. And this venture capitalist ultimately invested in an outsourcing firm in India, and he wanted to convert all of these clients to his company and take them away from me. Well, one of the business development people got online. They figured out who all my clients were based on the patents that I filed in the patent office and rang up every one of those, trying to convert them over. And there were my trade secrets, right? I had no way to really protect them all, but that gathering and knowing who they were, they were able to tell who my customers were, my clients were. I'm proud to say that none of them ever converted, but that's a way to take public information and do the mining and figure it out yourself. That could be a trade secret until it's discovered, right? And what's really interesting too about trade secrets, it's practically free. Once you set up the system, it's an internal system, an information system, there's no cost. Not like filing patents, filing trademarks, filing copyrights and things, right? Trade secrets are very attractive because as long as you can keep them secret, the cost is pretty minimal. So contrast it with other IP. I think it's important for everybody to understand this. I apologize for those who are already deeply involved in these different products, but it's important to understand the difference. And I think they get confused often by people who are maybe not specialists in intellectual property, right? So the different tools and how they're used. Patents protect novel technology, function, and structure. It really is all about the function of the operation of your technology. That's what gets protected in patents. Copyrights protect expression, certainly different, video content and things, but also software code is copyrightable as well. Trademarks protect brand. Trade secrets, interesting enough, protect all of those things to the extent that they're not published. So you could take a technology, an idea, something novel, something that's really key to your product, and every time you determine whether you're going to file a patent application, you want to consider whether to keep it a trade secret, right? In fact, I often will convince clients to keep more trade secrets than patents. You don't want to file patents that are going to disclose your trade secrets, because if they're not discoverable, if you can't tell that anyone is using this invention as it is, or they can't tell if you're using it, you'll never be able to tell if they're infringing your patent. So you keep it a trade secret. You keep it a trade secret. In fact, most companies should have more trade secrets. Well, certainly as many trade secrets as far as patentable technology as they do patents. And that's, I think, most common in technology companies. You can't possibly patent everything that certainly a large company produces. It's just not feasible. And it's also just not a wise investment to try to patent anything that moves, right? So what's interesting is the trade secret cost, again, is practically free. The life of a trade secret is indefinite. It could be as long as you keep it secret, right? Patents have a 20-year life, and copyrights have a longer life. Trademarks have a life as long as you're using it. But a trade secret, you don't even need to use it. As long as you keep it secret, it's a valid trade secret, right? And the strategic value is broader because it covers so many more things. Patents and copyrights and trademarks, these are things that you need to have certain criteria in order to file and register for these things. Trade secrets just need to be strategic. They just need to have its value in a secrecy, right? Enforceability, on the other hand, it's a bit complicated. It can be difficult to prove because in trade secret misappropriation cases, you need to prove that someone stole your secret and intended to do it. And it's not as easy to do that compared to, say, infringing a patent. You can infringe a patent accidentally. You just need to practice the claims, and copyrights similarly. So it's difficult to prove. However, given the cost-benefit analysis, just maintaining the trade secrets, it's really worth it. If nothing else, to protect certainly the loss of the trade secrets, the disclosure, but also to maintain the power of that trade secret in case it's misappropriated. So trade secrets are strategic assets, no doubt about it, right? And it's one tool in the holistic and strategic plan of a company. And you always want to consider things. I mean, they're trade secrets to start with. So you always want to consider the trade secret first, because that's what they begin with, right? Transferring them over to a different type of intellectual property should take some strong consideration, not just budget. And we'll get into that in another slide. It helps, just like patents and copyrights, it helps protect the valuable innovations that you want to keep exclusive. And it's the ultimate in exclusive if you can keep it secret. It also helps you, of course, restrain costs because they cost next to nothing. And especially since 2020 and profits taking such a big hit in most companies, I think trade secrets, this is why they're getting much more attention. And I think it's overdue. I mean, I've always emphasized trade secrets to clients, and it's often a wiser choice for certain types of technology or innovations because you may or may not enforce your patents. And you may have, you certainly have more flexibility in trade secrets, keeping them secret. It also kind of keeps it in the rear with the gear. Nobody sees it, and it avoids people having a blueprint for copying it like they might have when you file a patent describing your technology. Expertise for understanding how IP can be leveraged in negotiations is really key here too. Looking at the holistic plan, patents, copyrights, trade secrets. You want to understand how to use these things. Trade secrets, just like patents and copyrights, can be licensed, but they also have to have that extra degree of protection, because when you're working with some type of joint development, or having this third party, trusted or otherwise, or maybe even a competitor that you're dealing with, or a customer, you want to make sure that your trade secrets are protected. Very difficult thing to license, because unless you're able to monitor whether or not a company is using your trade secrets, you're not going to know if they are disclosing them to or using them in a way that you did not agree to. But education is really needed to understand how to be transparent with customers and others while still maintaining valuable secrets. And the key to that is in NDAs and all the different very complicated contracts that you can have with customers and partners, joint developers. It's really important to understand the contractual side of trade secret protection, so that you can understand how to maintain their secrecy in all of these different relationships. And what's I think key here too is that no one's going to do it for you. You must do it internally. You can't go to a judge or a court complaining about theft of trade secrets if you didn't take proper care and protect your trade secrets. Trade secret best practices. Again, I'm going to be sharing these slides with you. The following slides are there. I don't usually load up slides with information, but I think this information is it's important enough to give you something to refer to, because trade secrets, I got to say, it's one of the most underappreciated intellectual property, and it's really important to understand these things. And you could even probably derive checklists from these different slides for different people in your organization, including yourselves, just to remain and continue to be aware of trade secrets and how you're supposed to be taking care of them. So for the first one, barriers to public and unauthorized disclosures. Now, you've heard some of these are pretty routine, locked doors, password protected files, right? But there's more to it than just that. You want to limit access by those who actually need to know the information. Now, internally to a company, that's not always feasible. It may not even be that critical to the company, because when you share information, especially among technical groups, it's often best that they know everything, right? Because they're the ones who are developing the technology. But you're not only handling your own trade secrets, and you're not only handling them internally. Some companies are bringing in trade secrets of their customers, right? I mean, you're handling trade secrets, caring for trade secrets, and it's not really enough to hold these trade secrets according to your own standards. You need to be aware of what your customers expect of your handling of their trade secrets, so that you won't have any risk, right? So that's really where the liability is, trade secrets. When you bring them in and you're held to care for them, you need to be very careful and have procedures to protect them. And there are many outside third-party packages that you can use to help you maintain these things. But it's really important to bring in experts and to become an expert, especially for a company that is caring for other trade secrets. Certainly for the trade secrets that are for the company, that are key to the company, that are strategic, you want to make sure that you have those protected. But there's not so much liability there if you lose your own trade secrets. But if you lose or expose other companies' trade secrets, you've got problems. You've got liability problems. So it's really important to be aware of what you're bringing in, what trade secrets you're bringing in. And some, individuals or companies might try to infuse their trade secrets into you. Toy companies and other things. People always are ringing them up with ideas. Hey, I got an idea for a toy. I got an idea for a movie. I've got an idea for this technology, and they send it to the company. Well, you want to put those barriers up, because if they do that and somehow you come up with it yourself, that is the company, or someone uses that idea, then you've taken the trade secret that they shared with you. So you want to make sure that you have these warnings and barriers. So you don't want necessarily to bring in all of these ideas, because what they're trying to do is hook you, so that, to raise your liability and maybe get something out of it, right? So special care for third-party secrets, right? Trade secrets related to national security, government, and things like that. I mean, a lot of those are very strictly controlled anyway, but you'd be surprised at how often companies back into this, not really prepared to protect the trade secrets that are entrusted to them, whether it's from, it's not always like the Department of Defense, high levels of security, but it could be other information that can be important to the government, to your other customers, and important to you. You might be creating things, developing things, inventing things that are extremely valuable to you, and you want to keep those secret no matter how you disclose them to customers or other people. Contractual obligations with those who have access. Now, this is really important to really keep track of all of your contracts, standardize much of your confidentiality agreements, and understanding who gets access to your trade secrets. And if your company, your customers are sending you these, if someone else is controlling the contract, someone else is controlling confidentiality information, somebody else is controlling how you handle trade secrets, or someone is controlling how they are allowed to handle your trade secrets. And I'll give you an example. Some companies will have things called residual clauses, and some of you may be aware of these things. Residual clauses are a bit of a bizarre thing, and you can imagine you go into your employees go into a negotiation or a discussion, engineers, for example, and they're talking to another company's engineers, maybe a competitor, maybe they're looking to acquire you. You start having a discussion, and if there is a residual clause in there, it allows this other company to hear and see and learn your technology. If they go back to work and inadvertently incorporate it into their product, they get a free license. I know it seems bizarre, and anybody cynical would say, who would remember this and claim it as their own? It happens. But the key thing to remember is it's very difficult to prove. I mean, they show up, they take the information, they absorb it in, they send in people with these photographic memories, great memories and understanding. They go back and incorporate all of your technology, you're not going to have much of an argument. And also, if you get in front of a judge claiming that you have, someone stole your trade secrets, and they show this residual clause, it shows that you're lax in your protection of your trade secrets. And the judge is going to really look at this thing. He's not a trade secret expert, but he's seeing a person complain about something being stolen. It's almost like not locking your bike outside the grocery store. It's like, why were you thinking? Why did you put this residual clause in? Why are you loose with your trade secret information? So it's important to really put up big barriers and have the right attitude about trade secrets and show that you have, that you're proactive, you're deliberate, and you have the strong attitude toward protection. And if there ever is a leak, of course, you want to be able to pounce on that and show that you are aggressively and very deliberately protecting your trade secrets. Because in the end, you got to convince the judge, first of all, that you have a trade secret and that you are deliberate in protecting them. Recording secrets as they are created. Very important. So trade secrets can come about at any time. And there's a paper that I wrote, and I think we shared it with you earlier. We'll share it to anybody who wants it, regarding, it's titled, Everything Should Be Treated as a Trade Secret. Every secret should be born a trade secret, right? Every idea. And it's really important to understand that when these things are born, they come out of your mouth, they go on paper, they're shared in your work. They're shared in different ways. And you need to have your processes in place so that when these things come about in your research and your development, in these discussions, you want to make sure you want to capture them. And so that you record them, you get them written down, you get the author, whoever takes credit for it, just like you would a patent. Who's the inventor of this idea? And that includes all types of trade secrets, including customer lists. You want to make sure you record all of these things because it's best to show that you have possession of these trade secrets, right? There are third-party storage, recordings, logs, engineering notebooks is the old school way to do it. In the old days, engineers would walk around with these notebooks all the time. When they had a new idea in a meeting or whether working with other coworkers or even other partners, they write down drawings, explanations of this technology, this idea they came up with, and a manager would co-sign it. The inventor would sign it, the manager would sign it, and date it. And if you're ever called into a court saying, did you have this trade secret? Did you invent this invention? The engineer has their notebook. This is my notebook. I take copious notes. I have witnesses that show that I came up with this on this date. It's the old way to do it. Nowadays, you can send an email to yourself or to a coworker. And again, there's other products and different things that help record and serve to protect these things. Internal wikis. Wikis are extremely successful at capturing ideas from workers, from employees and other people that have access. You want to have very strict safeguards though, because those are all trade secrets there. And once somebody gets access to your wiki somehow, they're going to see all your trade secrets. So you want to have those barriers there. And like we said before, only the people who are necessary for access and who are authorized contractually by the company to see those trade secrets should see those things. Wikis can often be kind of loose, sharing ideas. It's the whole idea of the stream of consciousness and sharing amongst each other, especially now that people are working remote. But you want to have those safeguards in there, and you want to make sure that everybody understands how to use them. Verifiable timestamps. Why is this important, right? Well, imagine standing in front of a judge and saying, my trade secrets were stolen. This employee was working here. He left, went to a competitor, filed a patent application, and we saw it there. He took this trade secret, right? And in front of this judge, you need to show them that you had possession of this trade secret before this person allegedly took it and appropriated and used it, right? And there's a very large company in the Valley, a public company, who it's a bizarre story. There was a board member when they were a startup, was very cozy with this company, had his own desk inside the company. And he was a board member, one of the first investors, and he overheard this idea. And they said that they brought up this idea, they're going to use it sometime in the future. He took notes on it. And they said that they had no intention of using it now, maybe later. This guy went and filed a patent application on his own, in his own name, in the United States. This thing published, and the company, of course, flipped out. This guy was on the board of directors. He filed this patent application with his own name on it. He didn't even have a background in this technology, but he claimed it was his, right? He overheard it inside, and everybody knew it. At some point, they're standing in front of a judge in DC, federal judge, saying, you know, this guy stole our trade secrets. And the judge said, prove it. Show me in the documentation something that shows that you had possession prior to the filing of this patent application, prior to when you say this thing was stolen. They had nothing. They had nothing. They could not prove that they had possession of this trade secret. And they spent millions going after this guy for whatever reason, right? But it was unsuccessful because they didn't record it. And it could be something as simple as recording it in a database or sending an email. It's just describing the general concept of it and storing it away. And that's all you would have needed to do. And there wouldn't even have been a case. It would have been a very clear case of theft. You've got the trade secret existing and timestamped. This person filed a patent application afterward. He had access. He was on the board, for God's sake. Bizarre. But they couldn't prove it. They couldn't prove it. So timestamping is very important. And there's lots of different ways to do this nowadays. Of course, you know, the notebooks, third-party systems. Software escrow has been around for a long time. And companies often use it, you know, smaller companies, so that their customers, if the company ever goes out of business, they will have access to their code, to their source code, so they can maintain the software that they purchased, right? That's part of the contract deal. Inside that software, inside the code in the software escrow, all your inventions, at least all the inventions that are in your product, it's all there in the code. There's no more efficient or easier way to record your trade secrets than to put your code away, because it not only covers your code itself from being copied, it also describes all of the functional things that you could possibly patent and all the different trade secrets that are involved in that. There's a WIPO trade secret registry, and you file it just like you file a patent application. You pay a fee, you submit your trade secret. It's kept locked down and secret, but it gives you a secure recording of your trade secret along with a timestamp. Very valuable. So verifiable timestamps, if you walk away with one thing from this discussion, is record the thing, whatever that trade secret is, and get a verifiable timestamp, whatever that system is, right? And I'll give you a good example too, when you're dealing with patents and trade secrets, right? Often a company, when we meet with new clients and old clients, we have them come up with a list of ideas, novel technical ideas. That's the patent side of things. And you take this full list and you'll have the title, you'll have the author or the inventor, and you have a couple sentences in the context of your product. What is this thing and what does it do, right? And in that column are your disclosures, and we number them D1, D2, D3, on and on. And some of those will stay in that column as a trade secret. You've got it recorded, don't have to touch it. You've already got it recorded and date stamped. If you want to file a patent application, you move it to the next column. Now it's a patent application. It'll eventually publish. It's no longer a trade secret, so it's no longer in the trade secret column. So easy to do this. You can do this with Google Docs. You can do this with spreadsheets and different things. There's a really easy, cheap takeaway for you right now. If you're going to record your trade secrets, you have no system right now, do that. Come up with that system for all your ideas and all your trade secrets and list them, put them in a spreadsheet and timestamp them. And you just added a ton of value to your company today. So anyway, verifiable timestamps, very important, right? Education and awareness. I think this goes without saying, but it's worth saying and repeating and reminding, because repeating and reminding is extremely important in companies and even, law firms and different service companies, right? You hire a receptionist, you hire secretaries. We have paralegals, people who are handling the patent applications that we write, right? They're handling these trade secrets. So they need to be educated as to what a trade secret is, how you protect them, and you don't just, share these things. You don't talk to people about these things. It seems obvious, but, sometimes you have to have that firm grasp on the obvious and make sure that this happens so that all of the employees at different levels understand that trade secrets are important. They'll have, some will have more access to trade secrets than others, but whatever the case is, show that attitude about strong commitment to trade secrets so that if it's ever put into question or if anybody ever steals your trade secrets, you could stand up and show that you're a company that's extremely deliberate at protecting your trade secrets. Useful reminders, postings. It seems like very obvious things, but if you don't have them, people will forget. They're going to forget what a trade secret is and why they're protecting them, right? Especially if it's not the center of their job. Confidential notices around the information. So when you're sharing with third parties, people who are not under NDA or confidentiality restrictions, or even if they are, label everything. It takes away the question. It takes away the question, is that a trade secret? Is it confidential? I don't know. Should I share it? No, don't share anything. So when you're sharing with another company, you're talking technology, and if they're not within your circle of trust within the company, you want to make sure that it is explicit, not just in the contracts, but reminded in postings and different notices and in the documents that you actually share with them. Protecting third-party secrets entrusted to you. And we talked about this a little bit. Customers, partners, others that you invite into the conversation, often you are entrusted with third-party secrets. And it's not enough to protect them equally as yours. You want to treat them extraordinarily because that's where your liability is. Again, if you lose your own trade secrets, bad on you, it could hurt the company, sure. But if you lose somebody else's trade secrets, big problem. You could lose a valuable customer. You could be sued. You could be sued for loss of their valuable trade secrets. So it's really important to keep this information secret, or carefully keep this information secret to avoid any risk of loss. And to the extent that you can, keep it separated, siloed from your information so this is trade secret information of a customer. Extremely valuable, right? We don't ever want to mess with this, right? And of course, the company's reputation, if you're entrusted with customer information and there's a breach, it doesn't look very good, right? So you want to show that extraordinary attitude when it comes to handling other people's trade secrets for all the good reasons. And when in doubt, treat others' information as trade secrets. Even if you think it's not a trade secret, when a customer or anybody else gives you information, treat it like a trade secret. Categorize it as a trade secret. Label it as, customer information. Treat it as trade secret information. When in doubt, you'll have protection. Right. So when to transition trade secrets into other types of intellectual property? When and why would you do such a thing? Right? Everything's a trade secret to start with. So you have a trade secret. You have trade secrets that are being born all the time. Is what people are creating. And cost should not be the only deciding factor. But it is a factor. It's a huge factor. When you file a patent application in the United States, from filing until patent issuance, it's roughly, well, for many firms, it could be between $30,000 to $40,000. For filing in foreign countries, pick a dozen countries, and you're talking another $60,000 to $70,000. These are not small numbers. Most companies will not file all their cases foreign. They will, file maybe 15% of those, and they won't file all of their patent applications because it's just not feasible, and it's not always a great investment. And given 2020 and even some of 2021, when profits take a hit, you're not going to go crazy and file lots of intellectual property. You're not going to be spending a lot of money on that because the money sometimes just is not there, and you want to be strategic. Trade secrets are the answer. Trade secrets are the answer. As long as you can avoid any kind of discovery when you sell your product or when anybody else has access to your product, as long as you can protect it, trade secrets are an excellent alternative. So you want to see when you're transitioning, if you want to take a trade secret and file a patent application, the number one question you want to ask is, first of all, does it meet our budget? And is it key? Is it really this thing, this point of endearing value? Is it something that really differentiates you from the competitors? Great candidates for strong protection in patents. But the most important question of all of them is, can you discover this invention in a product? That is, when you sell your product, can somebody reverse engineer this thing, or in using your product, can they see this invention to the extent that they can copy it? It's a great question. And if the answer is no, that you cannot see it, it's an excellent candidate for trade secret. Because if they can't see it in your product, if they steal it and put it in their product, you're not going to see it there either. So why publish it? Why give them the blueprint of how to do this if in fact no one's ever going to see it anyway? Difficult to enforce a patent if you're not able to completely see that they're practicing your invention. One industry where they do lots of patenting, because secrets are very finite, is in computer chips. And there's an industry of reverse engineering in Southeast Asia that rivals any industry. I mean, they just shave down these chips and they can figure out your circuits, the materials, every single thing. So silicon companies, chips, the Intels, the AMDs, and other big companies, NVIDIA, they patent their technology extensively because it's easy to copy. If you have a trade secret and they reverse engineer your product, they can do that with impunity. It doesn't matter that they took it. If they're able to peel back your product and see how to make it and make it themselves, if you don't have patent protection or copyright or something else, then they can copy what you have. So you really want to look at your product and see, what is the availability of these different options? Can it be reverse engineered, right? Copyrighted software does not publish inventions, right? So when you're talking about taking a trade secret, maybe it's your source code, right? Maybe it's other types of information that you've got compiled. If you copyright your source code or any kind of computer code, you don't submit your entire code stack. Often in the old days, they would, you'd print out your source code. You take the first few pages, the last few pages, and you make a statement and you submit it for copyright protection, which is a very interesting way to do it. You're not disclosing really anything to the Copyright Office, but in good faith, you're submitting your code and it has copyright protection. So you can maintain even your copyrighted code as a trade secret, so long as it's not disclosed in what you submit to the Copyright Office, right? And you want to check assets for potential leverage or revenue. And this is all about trying to figure out, what do we have is really valuable? What do we have that gives us our competitive edge, that keeps us ahead of our competitors, or just we have these features that they just cannot do, or just at least they can't do it the way we're doing them unless they get this technology or information, right? So when you're negotiating with these different agreements, vendors, joint development, or even M&A, you want to be very cognizant of your trade secrets. You want to be able to understand how, when you're talking to vendors or maybe even customers, how much do you really need to disclose to them in order to do the business deal, in order to satisfy this other party or to uphold your contractual obligations. You don't want to give them any more than that. So you want to be aware as an IP expert and as this trade secret patent expert, you want to ask, and you might have to ask the technical people, what is this thing? What is this technology? What does it do? Give me the Reader's Digest version if you're not a technical person, but learn it as much as you can and understand, is that thing a trade secret? And how can we protect it? Do we need to disclose it in any given situation? So as you kind of picking up now, I think the more we talk, you need to be able to be very active and monitor these things. One of the questions that came up is, who is the best person in the company who can manage, the intellectual property portfolio, the trade secrets, all these different things? Well, it really does take a team effort, but it's best quarterbacked by the legal team, because they need to be the experts and have other experts near them, outside patent counsel and others, so they understand where the technology is. But they don't always have access to all of the technology in the company, because inside the company, there's all types of things, right? If this office were your company of intellectual property, this thing, you could fill the thing full of golf balls from floor to ceiling. That would be your trade secrets. Your patent portfolio, you might fit a file box. That really is the difference. There are so many trade secrets in a company at so many different levels, you can't possibly capture them all in patents. So again, I keep hammering this again, trade secrets are extremely important, and you need to understand how to handle them and how to really group them, right? Discovering intellectual property. So the question is, and this goes with the next slide too, what is the scope of a trade secret portfolio, right? How far do we go? It needs to be reasonable for the company. And my father would always complain when I would say things like this. He always said he wanted a one-armed lawyer on the one hand, but on the other hand, he wanted just the answer, and doesn't everybody, right? But the answer to this is, first, educate yourself. You want to audit the company. If you don't have an easily accessible portfolio of technology and description of what you have and what your products do, what your services do, what supports you, then you need to do an audit. And this is not an audit that's, drop everything that you're doing and shut down the company for 2 months kind of audit. This is something organic. You start asking questions. The best place to start that I've found is not necessarily with the engineers. You certainly want to talk to them. Talk to sales, talk to marketing. What are these differentiators? What is in your technological roadmap? What's in your product roadmap? What's in your business roadmap? Now we're talking about technology here. We're limiting the technology. Trade secrets are not just technology. Everything I'm talking about is trade secret stuff. But when it comes to technology, you want to make sure that you really understand what gives you that edge. And it might be a non-patentable kind of thing. It might be just these secrets that your company has that nobody else has that gives you this edge. So you want to ask all around the company, right? Maybe even the CEO knows. He's the one driving the ship. He knows what is the most valuable thing to him. And it might be different than what the engineers think and what the salespeople think in the marketing. It's funny, once you talk to inventors, I work most often with inventors, you ask them what the most valuable intellectual property is, and they will point to the most complicated technology that was painful to develop. It was so complicated, and these propeller heads, they really love technology. They love difficult things. And when they discover these things and they solve problems around these areas, it's amazing. It really is amazing. But it may not be the most valuable thing for the company. It might just be one of those things. So you want to ask around and get a good understanding and an agreement among all of the stakeholders, right? All the stakeholders in your company. What's valuable to them? What is valuable to this company? How do we make money, right? And it's important to understand that. Audit your technology stacks across the company. Again, it doesn't mean scour through every item of code that you have. But once you've got an idea of what this company depends on, what do the customers really like, you can start looking to see what enables that. What is it in the roadmap that we're after, that we're eventually going to develop, that's going to meet these customer needs, right? What are these things? And you want to get ahead of yourself and you want to protect these things. You know, with patents, for example, and with trade secrets, that's the extent you're recording them, you could look down the roadmap and you could look 2 years ahead and start recording. These are our ideas. This is our business roadmap. This is our technical roadmap. Document that. It costs you almost, well, it takes time, but it doesn't cost you any money once you have the system set up. Document it very well and you'll be glad you did. It's better to have them recorded and not need it than need it and not have it recorded, right? You want to make sure they record everything. And where do you look? You know, the bigger the company, the more places to look, right? These are inside business unit, among business units, intercompany, wikis. So there's the exhaustive list, right? You can come up with even more, I'm sure, right? Even publicly open technology, to the extent that maybe some puzzle pieces are missing or lines aren't drawn, where you have this information that says, yep, I see what they're doing out there. They're not doing what we're doing, even though we're using all the same pieces. Those are trade secrets and they're valuable too. And it's great to have a good, robust system that records those things. Again, the scope of the trade secret portfolio. You certainly want it to be harmonious with everything else that you're doing. Most of all, harmonious with the company doing business. You don't want it to get in the way of doing business. You don't want to be too militant about your trade secrets so you're not sharing it with anybody, because that's not practical. You have to share your trade secrets, certainly internally, but often with partners and customers that might even have their own technology, but they just don't do what you do and they need your thing, right? They need enough so that you could possibly just plug in your product. They might not need to know all of your trade secrets unless they actually need it to enable it. You want to understand that. And you need to understand it. Well, you need some technical help too, and make sure you understand, ask the engineers, ask the sales, what exactly does that customer need to understand about our product that we must disclose it to them. And they are just going to need to understand that, hey, we're letting you have this information. We believe that's what you need to implement our product and no more. The rest of it is our policy to keep it trade secret. And if they want more, they have to have reasons. They have to have reasons why they want access to this. And it needs to be, and they need to convince not just you, but all of the stakeholders involved, do they really need it? And that's the extent of your trade secret portfolio. And if they do need it, they should be under an obligation to keep it confidential to the extent that you're even capable of knowing that they're using it. Representations and warranties, contracts, caring for trade secrets about others, all of these different things. That's the scope of your trade secret portfolio. And as this process, your program develops, you're going to learn more about how to easily gather this stuff, right? Certainly being plugged in with the patent attorneys, whether they're inside or outside, they're in there, up to their knees in all the technology and everything that they're doing. The fact they shouldn't only be recording the inventions and the patent applications, they should be looking at your entire roadmap. So your entire roadmap has all of these trade secrets. So they should be a really great source of information for you when you're trying to learn, what do we have? What are our trade secrets? What are our things that we do that nobody else does? And if you ask the question enough, you start socializing these questions, you get to know people, building a relationship with these different stakeholders in the context of intellectual property, you're going to become this expert. You'll be a technical expert for the company and an IP expert for yourself and the company. We're getting close to the end. This last slide, I know I put this in almost every talk about intellectual property because I deeply believe in it. And I'm going to share it with you. I'll be brief, but I think it's really important. And I'm going to tell you a story around it too. Inclusion, diversity is fundamental to IP. So any marketing person, in fact, marketing person told me this, that if you want good ideas, she said, you need to have lots of ideas. Nobody has a monopoly on, all my ideas are good. No way. It's all about having lots of ideas. And that's in any context in business and even in life, right? The more ideas you have, the more likely you're going to have better ideas. And the more you socialize this, the more you're going to have. You will have more trade secrets to record, more trade secrets to leverage. You'll file more patents, and you'll understand what is really valuable. And it's important to make sure everyone is included from top of the company down. And often you'll see the founders of the company, their names are all over the patents, and they're the ones who have all the access to all the trade secrets. But the truth of the matter is, the people who are implementing these things are solving problems too. They're creating things, they're inventing things. And you want to throw that all into the mix. You might not file patents on everything, but you could certainly record the trade secrets. And that's what you really want, more intellectual property, right?
I want to say thank you, Dave. I think you did a great job. And now, all of my misconceptions about trade secrets have largely been erased, and I'm sure others feel the same. Next, I have a bunch of really, really interesting questions. The first question: if something can be reverse engineered, does that mean you cannot protect it as a trade secret?
Correct.
Wow.
If after it is reverse engineered, not just if it's capable of it. Once it's reverse engineered, your secrets are out. Those are not stealing. When somebody buys your product and tears it open and sees the secret, if it's not patented, it's yours.
Got it. How do you protect a trade secret if someone files a patent infringement case against you? And if you worked around the patent but don't want to disclose to the plaintiff how they worked around the patent, how do you defend yourself?
It's a good litigation question, right? Well, it goes back to what I was talking about too. On the other side of that, you don't want to file patents on things that people can't see. So in order for them to file a patent lawsuit against you, they need to have a reasonable belief that you infringe these patent claims. At least, every element of any one claim, right? So how do you defend yourself? These are trade secrets. We can't share them with you. Are you infringing? Why did you file a lawsuit if you didn't know I was infringing, right? You show me I'm infringing. That's really what the defense is, right? So that's where the battle comes. That's where the battle comes between the lawyers. And if it's truly a well-held and well-cared-for trade secret, you should win that battle, and they should not be able to see it. If they are not able to tell that you're infringing their patent, you don't have to share that with them.
Got it. The next few questions concern NDAs. And, shameless plug, we have an event on NDAs in like a few months. So obviously register for that if you're curious about NDAs. But here are the questions. They're really good ones that come up all the time. First question: what if you were asked by a counterparty in contract negotiation to list the trade secrets to justify the language on protecting trade secrets, right? How do you protect prevent the other party from, infringing on your trade secrets if they don't know what the trade secrets are? So that's like the first one. And this person says that this has come up a few times with respect to NDAs, where the NDA states that trade secrets are to be protected indefinitely. One more question on that is, if you provide the list of trade secrets, is it a violation of the trade secret protection requirement?
Right. Very good questions. Very good questions. For the most part, when these questions do come up, you should not have to disclose these trade secrets. And they just need to understand that if we share a trade secret with you during our discussions, during our negotiations, it's going to be well documented. We're not going to give you a list of our trade secrets for you to peruse through, mainly because once they have those, if they're really secret, you're not going to be able to tell if they're using it, right? I mean, this is a secret inside baseball thing that you should never learn. They should never learn your trade secrets. That is from the outside or even from your product, right? Otherwise, they're not trade secrets. You never get a list of trade secrets. And the question to them is, why do you need them? So you can avoid using our trade secrets? Well, if we don't share them with you, then there's no risk in you using them, right? And if you come up with them yourself, then that's not a trade secret. You came up with it yourself. If I teach you, so anyway, that's really the answer to it. And it also depends a lot on bargaining power too. Small company, big company, they could really be very demanding. You might really want this customer. You might really need this deal, and they're holding that over your head. In the end, usually they end up being reasonable. And if they're not reasonable, you got to question whether or not you really want them as a customer, whether you want to do this deal with them.
Got it. The next question concerns, the lead into the question is interesting. The questioner says it's common in routine customer NDAs to define a period of confidentiality protection and then carve out trade secrets and stipulate that trade secrets are protected for as long as they were made a trade secret under law. Does a broadly defined confidentiality agreement defend more than just trade secrets, or is there a risk that by sharing information under a short-term NDA without the trade secret carve-out, that possibly the trade secret the protection could be lost?
It could be lost. That's exactly right. It could be lost. Trade secrets should only be disclosed if it is, in fact, it should be mutual. That's actually a really good way out of it too, is that, look, we have this mutual NDA and we are mutually going to protect each other's trade secrets to the extent that we even learn them, right? So if you get our trade secrets, you're going to keep them isolated from yours. You're going to use them only to the extent that we allow you to, and you need to protect them just like yours or better. And we will do the same. That's usually what gets you out of that. Unless it's really one-sided where they have nothing to offer. Maybe it's a customer that really wants your product and they don't have any technology. And they'll do this mutual and there's no fear for them because they have nothing to share, right? But it's important to keep those barriers up. It really is.
If somebody else wants to submit a question, now is your time. And then after this question, we will go to virtual networking. But this question is an interesting one. It concerns TV pitches. So TV pitches or like ideas for TVs or for movies or, whatever creative, generally not under NDA. They mostly come through an agent and are almost always formulaic. There's rarely any NDAs as they're not considered copyrightable. Is a pitch for a TV show, for instance, or a novel or a movie, that possibly be a trade secret? And is there other protection that might apply if they're not?
There are. In fact, I'm very familiar with this. In fact, I've recently become very familiar with the movie business, and not from practice, but from creating some myself. And what I've found is much like talking to venture capitalists. They don't sign NDAs, right? And they just bring you in. They're like, no, just come talk to us. And the fear on that side is that they're going to take this information and give it to one of their portfolio companies. Say, hey guys, can you add this feature? They don't need to invest in this company that just came to them, right? And on the entertainment side, the core really is copyright and trade secrets. So how do you protect yourself? There's a couple different ways. We talked about copyright. So you can copyright things and they are still a trade secret, because you've got, for code, for example, you have this general description and it's not disclosed, and you submit that. So you can have some copyright protection in addition to the trade secret protection. Also, you can register your script or your treatment. There's different things. These are, Hollywood terms, right? These different things that you put together, your idea for a series, right? And you submit those to the SAG, to the Actors Guilds, right? And Writers and Actors Guilds, right? And you submit those, and those are kept confidential. And it's very powerful because, unlike copyrights, there's a bit of enforcement on that side. So that if you submit something there, the union is involved in every project that gets made. And if they see something similar to yours, they can put a flag up. And if you see this, let's say you see the series come out, you came up with your idea, you see it come out on Netflix, some other producer picked it up, this person you spoke to, took your idea and created it, right? It was a secret until they went and did that. Just speaking to them doesn't make it a non-trade secret. You get confidentiality provisions, you get protections, right? And when they take it and you've got it documented, date stamped and documented, remember? Date stamped and documented, then you've got them, right? So you can't expect to always get an NDA, but you stamp these things confidential. Mark them confidential. This is my idea. I'm sharing these with you, and that's it, right? That's how they do it.
Yeah, interesting. I didn't know that was an avenue.
Yeah, I got a question from another source that was about motivation. So they're talking about giving awards for patents. Often there's like this monetary award when you file, and then when a patent issues. There's some for copyright, but typically it's for patents because they're trying to generate more patents. Question is, should we do that with trade secrets as well? Sure, especially if it's a technical trade secret that's equal to a patentable technology. Just because you want to keep it as a trade secret and not file it, you still want to reward that, right? It could be something lesser than the full amount of filing a patent application, but they should get something because you want to encourage them, whatever it takes, to submit their trade secrets. And beyond that, we talked about motivation. It's all about the people, right? And when they're motivated, I mean, it's invaluable. It really is. The one thing about intellectual property, it gives documented proof, certification that this individual, whether it be an inventor or the person, the author of the copyright or the creator of the trade secret, it's certified proof that they created something that's never been done before. They put their human stamp on this thing. They solved this problem that no one ever solved before. Make a big deal about it. There's nothing more motivating. I mean, so I'll tell you a brief story about this. I know we're pressed on time. There was a company that I did work with. CEO, this is actually a good idea for everybody out there too. The CEO, every month they had an all hands. He'd have everybody show up, probably 150 people. And he would personally hand the award check to the person. They'd step up, shake their hand, take their check, and they would get recognized. And the CEO would smile upon them. Probably the only time they get access to this guy. And he was an amazing guy, right? Big, powerful guy, right? And it was incredible. I mean, it was really an experience. And there was a woman a young lady who was an engineer there, PhD. It was all male. It was, mostly, foreign immigrants who were working there. She felt small, right? And she worked on this audio visual technology that was really amazing. It really changed their product, solved a huge problem, right? So I told the CEO about it, about what this was, and to understand what she had done and who she is, right? And so he saved her for last. And so he handed out these checks and did all these different things and called her up. And I won't share her name, but I'll make up a name. So Soon Lee came up and she walked out. She's like bowing her head. She's shy, She reached out for the check and he would shake the hand just like when you graduate. And he held onto her hand. And she looked up and he pulled her back, like gently back, said, listen, I know what this took. He had a microphone, right? He says, I know what you went through. I know how hard this was. And I know how hard it is, to work in this environment and to invent things. And what you did was really special. And thank you. She broke down crying and wrapped her arms around me, changed her life. Suddenly, she was recognized. She felt 10 feet tall. And she eventually moved on and she's working for a big company now. And she has more patents than you can count. But I believe that was really the big motivation, the beginning of her career right there. And you can't put a price on that. As a manager, it's amazing what you can do with these things. Just recognizing that, right? It makes so many issues go away. I'm insecure. I don't feel like I fit in. I don't know if I'm contributing as much as that gray-haired guy in the corner, right? You've got this certified thing. And a trade secret can be just as good. And it makes you special, right? There's no better thing in my mind.